coming in and out, but we can probably go find them. I just tested this with a, I don't know what your question is, but I just tested it with a flash drive and it worked fine, so.
Same, yeah.
Do you have a question about like programs or?
No, I just want to make sure they have the slides.
Okay, right, okay. Shall we go look for them? I mean,
Sure, let us
Takes like 2 seconds. Let us explore. Yes. Cool. Yeah. You can actually just throw it right on here is the easiest way to do it.
Okay.
Should be open. Yeah, there's a USB here. I'll just test real quick. Okay. Should hopefully work out. Yeah. Cool. Yeah, just kind of hang out in the center aisle. Just try to get people to actually speak on this. They're like holding down here. Yeah. But I'll put these to you.
It seems to work just fine.
Let me show you where this is. If you click, save the image to the desktop, if you just click down there, that shows up. Okay, so you click again, it goes away.
Okay, so I just.
Percy, the rightmost.
Oh, okay, I see.
Okay.
No, we first have an introduction, and then do you have a
Yeah.
a thing like that? When after we pull this one out,
So I just stick it in.
or if you want. Excuse me, that may be somewhat important. Hello? Yes. Yes, Rachel. Yes, I mentioned so I'm going to have to call you back later. here it is. And you know how to use those.
Yes, because he said once it's in there, it just goes up and down. And it's got the pencil thing.
Yes, it doesn't work as great on the LCDs. The green works better, but I don't like the clickers that have green lasers. They have a lot of filters that are the same one.
So this one, once I've stuck my flash drive in and brought it up, that should automatically go
Once
onto
it's
that.
in full screen, the
Right,
slide should
and once we got it on the full screen, presume
that takes you forward and then
that
backwards.
that backwards. That's the stop, and you hit that if you find. Fantastic. Thank you very much. Well, this could be a scene from that movie.
But she thinks not. I just don't know how to do it. I'm gonna. Well, I can't really, can I? Just I don't know how to. You don't want to fiddle. I don't either. No. Well, I'll watch my videos and see how you do it. And I'll be able to do it myself. Oh. Well, we're not actually. They don't seem to have anything on their desktop. It's a bit like being in church, isn't it?
I'm sure we're going to decide if we qualify.
Yeah.
well. I don't know if you, does this work? Can you hear me well enough? I don't know if this serves, or I'll just speak up in case you can't hear me. Well, welcome. My job is a very simple one. I'm the person who welcomes all the people who have worked hard to make this conference possible. I'm Douglas Bio. I'm the director for the Center for European Studies at the University of Texas at Austin, which houses a couple of things: a National Resource Center funded by the Department of Education, as well as the EU Center of Excellence funded by the, as you can imagine, the European Union. And, you know, one of the presenters asked me just before I was coming up to talk and say a few words if this is the normal kind of conference we put on, and or that EU centers typically do. And I thought to myself, I said, I don't know, but I have a very capacious view of the sorts of things that this center should be doing. And I suppose I really have to do that because I'm not someone who works on modern Europe. I actually work on the Italian Renaissance. And I have always had a very capacious view of this, and the dean of my College of Liberal Arts has always had a very broad-minded view, and so have all the other deans who have contributed to the center in various ways, from Dean Hutchings to the deans of the College of Engineering to the School of Law. And I was really very gratified when I learned that my colleague, who was a classicist, had such a keen interest in this topic in the modern period. And I think that that's very typical. So we break all kinds of stereotypes, hopefully, about what centers should be doing or do, what classicists or Italian Renaissance scholars do or should do, and certainly what Texas may be doing or should do, right? I mean, this is not what everybody, I remember once years ago somebody arrived in Texas and said, it's not green. Or excuse me, it's not, it is green. I'm sorry, I got that backwards. It is green. Yeah. I really think that this is the kind of conference that I love to have and hope to always support, because it does bring us together around a whole set of shared values, or values that we can learn from one another. My other job is to sort of thank so many people that make these conferences possible. As a director, I often come into my staff and say, oh, I've just invited somebody, and they said, you just can't do that, because there's so many different things that go involved into bringing somebody over. But they really make this happen. And there are three people, two in my own center, Sally Dixon and Charlotte Harris, who have welcomed many of you already here, and Billy Chandler from the Rappaport Center. And that in itself is very important about our centers, that we work with all kinds of programs across this campus. So it's not just focused in the College of Liberal Arts, but we really work hand in hand with the Rappaport Center. Karen Engel, who's contributed to this as well, is having a marvelous series, a lecture series later on human rights and Europe and the US in the spring, connected to a class that she's teaching. I also have the pleasure of always working, there's Karen, she just walked in after I thanked her. Well, that was, of working with all kinds of different people on campus. And that's one of the delights of being a center director. People ask me why I like it so much. I often think of it as you're everybody's best or favorite uncle, because chairs often hear people ask them for money and they have to say no, but I get to say yes a lot of the time. And yes, sometimes in spades, because it really seems to me something that I want to assist and fund and work on. And I was really gratified, Tom, to work with you on this, to work with every aspect of this with you. And the amount of time Tom spent on this is truly remarkable. Gathering people, arranging things, working hand in hand with the staff. So I give you Tom Hubbard, who has really put this thing together. I thank you.
Thank you, Douglas. I, for my part, want to welcome all of you here. This is really a very audacious and unique international enterprise we're engaged in, and we're so grateful, particularly to our visitors who have come so far to help us figure out what we in the US may be able to learn from European experience, which in the realm of sexual human rights has perhaps been a few years in advance of what we have succeeded in legislating in this country. But there is much from both the successes and the limitations of European experience that I think we have to learn. I want to acknowledge a few Douglas told you much about the European Union Center for Excellence and the EU and its support of interdisciplinary efforts like this. There are a few things I want to tell you about some of the other sponsors whom I want to thank, including the Center for Women's and Gender Studies, the Rappaport Center for Human Rights and Justice, the Department of Germanic Studies, the Swedish Endowment, the Outlaw, the gay and lesbian group of law school students, many of whose volunteers you have helped greet you or bring you from the airport to our conference. And in particular, I would like to say a word about the William A. Percy Foundation, which has, there we go. And I even have a short statement from William A. Percy, which I'm going to read for you about the conference. This conference seeks to tackle controversial topics at the intersection of current debates on age, gender, and sexuality in the US and Europe, including UK and Ireland, as well as the former dominions. A major theme of the conference is a critical look at key differences in how the legal systems of US and Europe deal with issues such as gay marriage, age of consent, kiddie porn, the sex offender registry, transgender rights, and prison sentencing for sexual crimes. Why, for example, is a 14-year-old in Austria treated so differently from a 14-year-old in the US with regard to their respective capacities to consent to sexual relationships? Why do adult sex offenders generally face significantly longer sentences in the US than their counterparts in Europe? Sexual identity is something that now permeates so much of what it means to be a citizen in Western liberal democracies. Whereas social constructionists often stress the fluidity of gender and sexual categories, strategic essentialist slogans of "I'm born this way," put forward by some LGBT activists, rest on firmly embedded genetic, medical, psychiatric understandings of sexual being. Indeed, the very concept of sexual citizenship, although one that is perhaps unfamiliar to many, is increasingly used now in sociology as an all-encompassing term to denote the fact that genders, sexualities, and bodies matter in politics. However, rights of free expression, bodily autonomy, and institutional inclusion are ones that have often led to fierce debates in both Europe and the US. For example, strong protests erupted in France around the issue of gay marriage, with opposing political and religious traditions locked in seemingly irreconcilable sides. Here, as in the US, long-standing religious beliefs over marriage's union between man and woman have clashed with broader inclusive notions, which demand such institutions be open to other sexualities. The conference will address how these conflicts impinge on not only what it means to be a sexual citizen, but how citizenship rights are differentially applied and on occasion denied to individuals within the criminal justice system and to those deemed minors. Again, identified discrepancies in the way such issues and categories are dealt with between Europe and the US will hopefully inform and enrich debate and academic theorizing on sexuality, gender, and culture. To that end, this forthcoming conference is of critical importance. So, with our thanks to Mr. Percy and his foundation, I would like to proceed to our first panel on issues of same-sex marriage and family, and particularly to introduce our keynote speaker, Dr. Helmut Graupner of Vienna. As you see from his long biography in your program, he's a man whose accomplishments and service to the cause of sexual human rights I could not even begin to describe in the kind of brief introductions we're doing here. But let it suffice to say that he is one of the major litigators in the European Court of Human Rights, and someone who has really achieved significant gains for sexual minorities in the human rights area. And he is here today going to talk about some of the cases that he's dealt with and the case law of the European Court of Human Rights more generally. So I present to you Dr. Helmut Graupner. Thank you.
Can everybody hear me well? Thank you very much. Thank you very much for the honor to supply the opening presentation. I feel very much honored. And my presentation is about, as you see on the screen, on sexual orientation, which is usually understood as homosexuality, heterosexuality, and bisexuality, and an overview on the case law of the European Court of Human Rights on this issue. In the Christian countries, homosexuality has been a capital offense, traditionally, an offense punishable by death, traditionally by burning alive. And the first country which did away with the death penalty was the country where I'm coming from, which was a little bit bigger those days than today, but in fact it's the same country still. And so we did away, as the first country in the world, with the death penalty for homosexuality. But we have not done what 2 years later France did as the first country, namely to decriminalize same-sex contacts. We just lowered, remarkably, the sanctions, but we did not really decriminalize it. France made a start, and other countries followed, so that today we have, in the whole of Europe, practically no country anymore where we have criminal law discrimination. We have no country anymore with a ban on homosexuality, and practically no country anymore which discriminates in any way against homosexuality in the criminal law, which has special criminal offenses against homosexuality, as it was widespread and common also in Europe in past days. After the Second World War and the tragedies which came with it, and the Nazi power in Germany and over Europe, Europe made a restart, you can say. It founded the Council of Europe, and all the member states of the Council of Europe engaged to sign the European Convention on Human Rights for the Western European countries those days. It's a precondition to enter the Council of Europe, to have signed the European Convention on Human Rights. And the European Court of Human Rights is the court which is competent to make final decisions, final judgments on the interpretation of this European Convention on Human Rights. It's the highest judicial authority in Europe, and the Council of Europe these days consists of all states of the whole geographic continent of Europe, which is 47 states with only one exception, which is Belarus. But the court is competent for over 800 million people, and it has the power to give binding judgments. So the judgments the court issues are binding for all the member states. So these are not just views like for United Nations bodies, but they are real judgments which are binding. So what did the European Court of Human Rights say on homosexuality, heterosexuality, sexual orientation, or on sexuality in general? In its case law, which is quite rich those days, it said, for instance, that the very essence of the Convention, of the European Convention on Human Rights, is respect for human dignity and freedom, which is the very essence of the idea of human rights in itself. That the notion of personal autonomy, self-determination, is an important principle underlying the interpretation of the right to respect for private life. Respect for private life is one of the rights enshrined in the European Convention on Human Rights in Article 8. And that sexuality and sexual life are at the core of the fundamental right to protection of private life, and that state intervention interferes with this right, and each intervention with a convention right, also with private life, so also any interference with sexuality, any interference with sexual life has to be justified, and it can only be justified if it's demonstrably necessary to avert damage from others. So any state legislation, any interference by state agencies into your sexual life is only justified if these preconditions are met. And the court says that it's only necessary if there is a pressing social need for a regulation or for another interference, and if upon such a pressing social need any measure is taken, this measure is proportionate to the aim which it seeks to fulfill. So a pressing social need and proportionality, these are the two criteria which are the most important ones. And which is one of the most important things in the jurisprudence of the court and in human rights discussion on sexuality as such, is that attitudes and moral convictions of a majority cannot justify interferences into the right of the private life or into other human rights. So the sole reason or the sole fact that other people do not like what you are doing in your sex life, or even if all other people than you and your partner, or all other people than you yourself, do not like what you are doing and say it's immoral, that matters for them, and they can hold this opinion. That's their freedom under human rights as well. But that does not entitle the state to interfere into your sex life. That's one of the most fundamental things the court made clear. And it is incompatible with the underlying values of the convention if the exercise of convention rights by a minority group were made conditional on its being accepted by the majority. So the freedom and the rights of homosexuals, bisexuals, for instance, are not dependent upon the acceptance of these rights by the heterosexual majority. Examples for case law you see at the bottom, so it's quite a number now. That was the freedom rights, and now we turn to the equality rights. The court made also very clear that discrimination on the basis of sexual orientation is unacceptable, plain, no any relativity, it's plain unacceptable. And it is as serious as discrimination on the ground of race, ethnic origin, religion, and sex, and the consequence is that any differentiation on the basis of sexual orientation, as any differentiation on these other grounds, requires particularly serious reasons, or as the court says in some other decisions, convincing and weighty reasons, otherwise a differentiation is discrimination and inadmissible. The margin of appreciation for the member state, which the court normally grants to member states in their legislation and in their activities, is narrow in those areas when differentiations are made on these grounds, including sexual orientation. And distinctions must not only be suitable or wise, they must be necessary to realize a legitimate aim. And distinctions solely based on the basis of sexual orientation, if there is no other ground or reason than just to the desire to make a distinction between different sexual orientations, then this is plain discrimination and inadmissible. And the convention not just awards to people negative rights, to freedom from state intervention, which is the classic understanding of human rights, but also positive rights to active protection of these rights in relation to the state, but also to other people. Your human right to life would not be effectively protected if the state does not kill you, but if the state would keep passive if other people want to kill you. So your right to life is only really effectively and comprehensively protected if the state not just refrains from killing you, but protects you also from being killed by other private people. And this is not only so in relation to the right to life, but also in relation to other rights. So also in relation to the right to private life and the right to self-determined sexuality. If you are suffering from interference with this right, then the state, under certain conditions and in some respect, has also an obligation to take active measures. In 2000, the court also decided that it's inadmissible to base disadvantageous treatment on human rights violations which have occurred in the past. No matter if the person which suffers today from a human rights violation which took place maybe 20, 30, 10 years ago, it doesn't matter if the person then back those days raised a complaint. It does not matter if the human rights violation back those days was already recognized as a human rights violation. But if this situation, this historic situation back those days, has negative consequences today, this means that the state has to refrain from such negative effects, and it has even the obligation to actively remove negative effects materializing today as the result of historic attitudes, which we today see as discriminatory or as a violation of human rights. This Dutch decision was on pension rights, and women received a lower pension, not on the basis of recent differentiations, but based on differentiations already back in the 50s of the 20th century. And the Dutch government argued that those days things were seen differently, and today we are treating women equally. But these are the results of prior discriminatory attitudes, and so you cannot do anything about it, and that's not a human rights violation. The court did not agree. It said, yes, but you are Dutch state, you are now paying the pension. You are paying the pensions now, and you have you cannot make undone the discrimination back 50 years ago, but you can raise the pension today, and that's what you have to do. So if you come to the several areas of law, what the European Court of Human Rights did in relation to sexual orientation was at first, as a matter of course, to decide that total bans of homosexuality violated Article 8 of the European Convention on Human Rights. You remember the right to private life. It was almost a quarter of a century before the United States Supreme Court did it in 2003. And the United Nations Human Rights Committee in Tunen versus Australia in 1994 followed and decided the same. So this is a case law which now applies to globally, with the difference that the UN Human Rights Committee cannot issue binding judgments, but for Europe, the European Court of Human Rights can do that. The next thing was to decide, because the United Kingdom did not believe that, the court said that this inadmissibility of a total ban not only applies to 2 people in private, it applies also to 3 or 4 or even more people. The only thing which is relevant is not how many people having sex, but the only thing relevant is if they are consenting and if they are doing it in private. So also group sex is a protected activity under the European Convention of Human Rights, as long as all participating people are consenting and doing it in private. The next issue was age of consent, minimum age limits for sexual contact. And in 2003, the European Court of Human Rights decided that higher ages of consent for homosexual contact than for heterosexual contact violate Article 8 and Article 14 of the Convention on Human Rights. Article 8, right to private life. Article 14, the right to be free from discrimination in the enjoyment of the right to private life. So the age limits have to be equal, regardless of sexual orientation and the gender of the partners. But the repeal of such a higher age of consent is not enough. Victims must also be rehabilitated and compensated, also if acquitted. That's what the court said in several decisions. It's not enough to persecute someone, to enter criminal investigations, to prosecute someone, to bring him before court, and then acquit him and say, okay, that it was, but we don't pay you any defense costs, we don't make good any of your psychiatric problems you have as a result of this, maybe. So you have to be compensated, and as a minimum, the state has to recognize that it was a human rights violation. And one of my clients was SL, who was different than the other applicants, not an adult, but he was a minor. He was 17 years of age, and he complained to the European Court of Human Rights and said, I'm the one who the state says he wants to, or it wants to protect. And that's why the state prosecutes and persecutes my adult partners, or the partners I want. Because SL did not want peers. SL was not interested in other 17, 16-year-old guys. He was interested in older guys. He wanted adult men. That's what he liked. And that was criminal, not for him, but for the potential partners. So he could refrain from sex, or he could engage in sex with the people he liked, older partners, and then by that endanger them to criminal prosecution and endanger himself to be coerced in criminal proceedings to testify against his partners. And that's why the European Court of Human Rights found not only the adult persons who get prosecuted, involved in criminal proceedings and convicted, that not only their rights are violated, but also the rights of the adolescents were violated, who consented to the acts, who wanted them, and who were partners to these relations. And so also SL was awarded compensation. He got 5,000 euros plus costs and expenses for his not being able, between the age of 14 and 18, because the general age of consent in Austria was and is 14, which is the same for every sexual orientation, but there was a second one in addition, which was 18 for just male homosexual acts, that he was spared by that law from entering into self-determined sexual relations with older adult men. So, the next thing, I have just one in this year, some weeks ago. The court issued a judgment on entries in criminal records because Austria wanted to keep the convictions in the criminal records of the convicted persons, even though the Court of Human Rights has found these convictions to be in violation of the Convention on Human Rights. And now the European Court of Human Rights confirmed that, of course, these criminal records have to be deleted. Remember what I have said before. Human rights violations in the past, states are obligated to actively remove any negative consequences which are still lasting from prior human rights violations, even if those people have not complained. And so this is a confirmation of this principle. A decision not of the court, but of the former Commission of Human Rights, which does not longer exist, a ban on pornography, in this case homosexual pornography, among adults and without unwanted confrontation of others, is also a violation of the right to free speech, right to free communication in Article 10 of the European Convention on Human Rights. The case concerned the showing of male homosexual pornography in the back room of a sex shop to adults, to gay adults, and that was prosecuted in Switzerland, and the Commission found it in violation. So also pornography enjoys the right, the protection of the right to free speech. So let's leave the criminal law. It lasted too long in relation to homosexuality. Now we have overcome that in Europe. So we are dealing with other issues like employment. Inquiries into sexual orientation and dismissal on the basis of homosexuality violate the right to private life, Article 8, and that also in the armed forces. These cases concerned the armed forces in the United Kingdom, where gay men were not allowed to serve. One of the very few countries in Europe which had such a ban. And recent cases, right to assembly, ban of gay pride parades violate the right to assembly, enshrined in Article 11 of the European Court of Human Rights. And in these decisions, the court made very strong statements that any measures interfering with the freedom of assembly and expression, other than in cases of incitement to violence, of course, or rejection of democratic principles, do a disservice to democracy and often even endanger democracy. However shocking and unacceptable certain views or words used may appear to the authorities, they may not ban it, and conferring substantive rights on homosexual persons is fundamentally different from recognizing the right to campaign for such rights. So even if a state does not want to grant the right to marry, for instance, or a right to adoption of children, that does not in any way entitle the state to ban campaigning for these rights. You always have the right to say that you want to change the law, even if you don't have a right that the law be changed, but you have a right to say that you want it to have to be changed. Incitement to hatred, what about that? In a Swedish case, persons convicted in Sweden for incitement to hatred on the basis of sexual orientation complained to the court that they have been violated in their free speech, but the court made clear that the right to free speech and the right to free communication does not protect incitement to hatred. But the convention protects homosexual, bisexual people from homophobic violence, and not only in the sense that it has to sanction such violence, that it has to engage in criminal investigations, but it has to pay special attention to this special homophobic motive of the crime in investigation. So the states are not allowed to treat this like any other offense, like any other violent offense. They have to take care of the special aspect of such cases, like in racist violence cases. And discrimination of LGBT, lesbian, gay people cannot be justified by religious convictions. So the freedom of religion does not justify discrimination on the basis of sexual orientation. In a decision also of this year in Nevada and others with the United Kingdom, the court made clear that member states are entitled to outlaw discrimination on the basis of sexual orientation, even if a person, if a discriminator says that this person discriminates or wants to discriminate on the basis of firm religious convictions. These cases concerned in two examples of such religious motivated discrimination. The first was a woman working as a civil servant in a registry office in the United Kingdom, and she said she is a Christian and does not want to solemnize registered partnerships between persons of the same sex. And she was sanctioned by the employer, and she complained to the court but lost. And the same therapist, a psychotherapist working not in free practice but with an institution which had an anti-discrimination policy, was on the basis of sexual orientation, and this institution terminated the contract on the basis that he refused to serve same-sex couples, and he complained also to the European Court of Human Rights that that would have interfered with his freedom of religion, and the court also denied this in his case and said that freedom of religion does not mean that you may discriminate against other people. It means that you can hold your religious views, but it does not mean that you can hurt others. So partnerships, same-sex partnerships. Already 10 years ago, the European Court of Human Rights decided the case Karner versus Austria, and this principle has been confirmed in a lot of cases, as you see on the bottom. States are not allowed to treat unmarried couples differently, whether they are same-sex or opposite. So homosexual couples always have to be treated the same way, at least, as unmarried heterosexual couples. So all the rights which states confer to unmarried opposite-sex couples, men and women living together, even if not married, all these rights also have to be granted to same-sex couples. This view has been adopted in the meanwhile also by the United Nations Human Rights Committee for a territory much bigger than Europe. For parenting, there was a decision also already in 1999 from Portugal. Mr. Da Silva Mota was a man who was married in a heterosexual marriage and they divorced, and the courts, the Portuguese courts decided not to award him the custody of his daughter, but his former wife, the mother of the child, and that in these decisions they referred to his sexual orientation and to the fact that he lived with a man in a partnership. It was not the sole reason for giving custody to the mother and not to him, but the court said at first discrimination on the basis of sexual orientation is unacceptable. In relation to custody and decisions on children, no relation and relating in court decisions to sexual orientation in a negative way is acceptable. And even if only one of several reasons the court gives in a decision is or refers to sexual orientation in a negative way, this makes the whole decision a violation of human rights. The next one was single adoption, which means a single person, an individual wanting to adopt a child. This was not allowed in France, being the only country in Europe not allowing single persons to adopt children on the basis of their homosexuality. And the court found that this is a violation of Article 14 of the right to be free from discrimination, right to equality, and it was a Grand Chamber decision. The European Court of Human Rights consists of chambers with 7 judges and one Grand Chamber consisting of 17 judges, and each judgment of a chamber you can appeal within the European Court of Human Rights to a grand chamber, and the grand chamber gives a totally final judgment. It's the absolute highest authority in Europe on human rights issues, and cases can also be decided at first hand by the grand chamber without a prior decision by a chamber. At the beginning of this year, in February, the court issued a very important decision on second parent adoption. So this was the next step after single adoption. Next step, second parent adoption. You remember the Karner principle? States are not allowed to treat differently unmarried couples, whether heterosexual or homosexual. And then look at the case EB. There is not a ban of adoption of children for persons on the basis of homosexuality. Individual adoption is not allowed. If you combine these cases, the result is ICSID, others. Because in Austria, second parent adoption was not restricted to married couples, but also opposite sex couples, if they have not married, just cohabitated. They were allowed to adopt the partner of the child of their partner, but not for same-sex couples. So that was, in our view, exact a discrimination like in Karner. But the question was whether the court was ready to expand the Karner principle also into the family law and into adoption of children, or expand EB into the sphere of partnership rights, because EB was about single persons' rights. And especially as the court traditionally looks, the court always have to keep its authority, of course. If the court issues great judgments, but nobody cares about it, then we don't have anything from it. So the court has to look that and watch that its decisions are accepted. So it looks on the consensus in Europe. How many member states have a certain regulations, how many do not. So in second parent adoption, it was the case that only 11 states allowed for second parent adoption of same-sex couples, and the rest, 36, so the vast majority, did not. And so the question was whether the court was prepared to find such a fundamental right, and it did in 2013, and it was a grand chamber decision, so with a particular authority, and with a majority, which is not tiny, which was 10-7. And in this decision, the court made very important statements. It said all three, so not just the mothers, not just the biological mother, not just the stepmother, but also the child were directly affected by the difference in treatment and could claim to be victims of the violation. That was very important for us to argue that it's not only about discrimination of the partners, it's primarily about discrimination of the child in relation to children growing up in heterosexual partnerships. It's primarily about disadvantage of children living in rainbow families. All three, the mother, the stepmother, and the child, were affected as a family, the court said, and made clear, by the violation, and therefore, because they were affected as a family, the court made a joint award in respect of non-pecuniary damage. It did not say, you mother get this, and you stepmother get another amount, and the child get another. It made a joint award because it was a joint entity. It was and is a family. The court emphasized, like in other decisions before, not on homosexuality, but in other aspects, the importance of granting legal recognition to de facto family life. So more important than normative views on what a family should be is that people are leading de facto a family life, and the states are obligated to protect these de facto family life. And that cannot be underestimated in its importance. The burden of proof for the necessity of a distinction based on sexual orientation is on the government. You have heard before for a difference in treatment based on sexual orientation, like on race and sex and religion, etc., you need very weighty reasons, particularly really serious reasons, convincing and weighty reasons. A differentiation has to be necessary, but who has the burden of proof? That in practice in court is utmost important. And the court made very clear that this government has the burden of proof if it wants to make a differentiation, if it wants a certain group to enjoy fewer and lesser rights or inferior rights than others. And the court said that there is not just one way or one choice when it comes to leading one's family or private life. So the court underlined the principle of pluralism in the interpretation of the Convention on Human Rights. And the court concedes that states, of course, have the right to protect the traditional family, but the protection of the traditional family has to be balanced against the Convention rights also of sexual minorities. And, as we said before, the margin of appreciation is narrow for the member states in this regard. And the court found, in the end, no evidence that it would be detrimental to the child to be brought up by a same-sex couple or to have two legal mothers or two legal fathers, because that was the argument of the Austrian government. We do not allow that because we do not want that in our legal system children have two mothers or two legal fathers. The court found nothing bad about that. And even the dissenting minority, the 7 judges which did not like the decision of the majority, even they stated that the 3 applicants, the 2 women and the child, enjoy the protection of a family life. So in this regard, the decision was unanimous even, and that the child received the proper upbringing from his mother and her partner. So in this aspect, the judgment even was unanimous. And this judgment has been issued despite the fact that the vast majority of member states did not yet have second parent adoption. The reason is that the vast majority did not allow unmarried heterosexual couples to adopt partners' children, so they were not affected. So the court could issue this judgment for the small group of member states who were directly affected, but nevertheless it cannot be underestimated how important it is what the court has said. Marriage is the next issue. Article 12 of the European Convention of Human Rights grants the right to marry. And the court already 13 years ago said that this right to marry includes the right to marry a person of the same biological sex. But it was not about same-sex marriage as such. It was about transsexual marriage. The court decided that post-operative transsexuals have the right to marry a member of his or her former sex. But with this decision, the court recognized the right to marry a person which is of the same biological gender or sex. It is not of the same psychological or social gender, but of the same biological gender. So it is a first step. And let's look at the reasons the court put forward to find this decision. The court said there are major social changes in the institution of marriage since the adoption of the convention. Always think on same-sex marriage as such. So marrying a person who is not just biological, but also psychological and socially of the same sex. Wouldn't that apply as well? A second argument, dramatic changes were brought about by developments in medicine and science in the understanding of transsexuality. Well, I think that's the same in relation to homosexuality and bisexuality and sexual orientation. And it rejected as artificial the argument of the British government in those cases that post-operative transsexuals had not been deprived of the right to marry because they remained able to marry a person of their former opposite sex. So the British argument said a trans woman can marry a woman because she keeps to be a man legally. But the court said no, the applicant lived as a woman and would only wish to marry a man, but had no possibility of doing so and could therefore claim that the very essence of her right to marry had been infringed. So the court made very clear that member states do not have to base their legislation on artificial situations, but on the real situation people are living in, applicants are living in. And the inability of any couple to conceive or be a parent to a child cannot be regarded per se as removing the right to marry. And this is a literal citation from the judgment. So why then not real same-sex marriage? Isn't that also an argument why two men, two women, not being transsexual, not having changed sex, should be allowed to marry? But even more, the European Court of Human Rights said that Article 9 of the Charter of Fundamental Rights of the European Union. European Union is the second international European organization on the continent of Europe, consisting of fewer countries, 28 countries now, Council of Europe, 47 countries. Closer integration, but fewer countries. And the European Union adopted a Charter of Fundamental Rights, mirroring the European Convention on Human Rights in the bigger Council of Europe. How can we decline?
Yes.
Okay.
We don't want her yet.
And the Charter of Fundamental Rights of the European Union did not speak anymore about men and women having the right to marry. In the European Convention of Human Rights, which is from the 1950s of the 20th century, there's a reference to men and women. In Article 12 of the European Convention on Human Rights, it's said that men and women have the right to marry. It does not say that men and women have the right to marry each other. So even on that basis, same-sex marriage should be possible. But the Charter of Fundamental Rights of the European Union even leaves out any reference to men and women. And the European Court of Human Rights already in 2001 said that that was not only by coincidence and that it's not irrelevant, that it's not relevant. It is relevant because it was deliberate. So it makes a difference. It was by that's what the adopters of the Charter wanted, and that has to be. The court has to base its findings on that. So if you look at all these arguments, you would think that the next decision would be to allow same-sex marriage and to find that it's a violation of human rights if a member state does not allow same-sex marriage. But unfortunately, that's not the case. In Schalk-Kopf, again an Austrian case, of 2010, same-sex marriage, non-transsexual marriage, but same-sex was an issue, and the European Court of Human Rights was hesitant to fully apply this line of argument also in the marriage for fully same-sex partners. But it said, for the first time, we have heard it already for X and others 3 years later, but in 2010 the court found it for the first time that the cohabiting same-sex couple form family life and enjoy the protection of family life under the Convention on Human Rights, and not just this, but just as a relationship of a different sex couple. No difference. It's a family just as a heterosexual family. And that has been confirmed in other judgments. The right to marry, enshrined in Article 12 of the Convention, is applicable to same-sex couples, so have the foot in the door, as you may say. So the right to marry, enshrined in the European Convention on Human Rights, is applicable to same-sex couples. So it's not the case anymore that you may say that's a totally different thing, that's not marriage, marriage is only between men and women. The court said differently. It's applicable. The right, the basic right, fundamental right to marry is applicable to same-sex couples. But, a big but. When the court issued this judgment in 2010, it has been only 6 out of 47 convention states which had allowed same-sex marriage. So the court said, as matters stand, and that's are the most important 3 words in the judgment, I think, as the matters stand, same-sex marriage is not yet part of the very essence of the right to marry, enshrined in Article 12. So the right is applicable, but it can be restricted because same-sex marriage is different than opposite-sex marriage as not belonging to the very essence of the right to marry. So member states may prohibit same-sex marriage. Article 12 reads like this: men and women of marriageable age have the right to marry, it does not say each other, and to found a family, according to the national laws governing the exercise of these rights. As a matter of course, national laws are not allowed to restrict the very essence of the right. They can regulate marriage age and such things and ceremonies, but they are not allowed to do away the very essence of the right. And what the court found in Schalk and Kopf is that the right is applicable, but it's not in the core part of the right that may change in the future. There was another question in this case before the court, which was decided by a very tiny majority of 4-3. The marriage thing was unanimous. The question whether Austria, which introduced a registered partnership by 1st January 2010, has been too late. And the court found with this tiny majority that it was not too late. And the dissenting minority of 3 judges said that the failure prior to 2010 to provide same-sex couples with some form of legal institution would have violated Article 10. So it was already very tiny, so that you can guess that in future cases, we have now 3 years have passed in the meantime, and that the court might find differently for other states which are still refusing any institution. And the situation for Austria was very special because Austria, during the proceedings before the Court of Human Rights, introduced registered partnership, so the court wanted to be polite and not to punish the member state which was so obedient as to take the proceedings as an occasion to introduce the partnership and then proudly report to the court, we have done it, please close the case. And the court did not close the case. They said it's a matter of general importance. We want to issue this judgment. They did not close the case, but they said, well, Austria, it was quick enough. And my last slide, most recent case, Valianatos, a Greek case, also from the Grand Chamber, with a very big majority of 16-1. Maybe one step further towards same-sex marriage under the European Convention on Human Rights. The issue in Valianatos was registered partnership, or civil union as you may call it, which in Greece is allowed only for opposite-sex couples. So Greece adopted registered partnership, introduced the registered partnership, but not as most countries in Europe which have introduced registered partnership for same-sex couples or opposite-sex and same-sex couples, but for opposite-sex couples only, and excluded same-sex couples. So heterosexual couples then had 2 choices: civil marriage and registered partnership, and same-sex couples still had none, 0, no chance of a formal recognition of their partnership. And in the marriage case, Schalk and Kopf, the court referred to 100 years of traditions or 1,000 years of traditions and social roots of marriage and understanding of marriage in the member states, so it has to be very hesitant to finding a violation. But registered partnership is a new institution. It's invented it has been invented some years ago. So are states allowed to invent a new institution and model it just for heterosexual couples like marriage, because marriage can be reserved for heterosexual couples? The court said no, it violates the right to equality, vast majority of 16-1. The one judge who dissented did not dissent on the merits, that it would be an inequality and discrimination. This judge just said it would have been beyond the power of the court to make an issue, a judgment on this issue. The court said same-sex couples are not allowed to marry in Greece. So they have a particular interest in a civil union as sole basis to have relationship recognized. So if they're not allowed to marry, the only thing they could enter to, or the state could allow them, was as an alternative registered partnership. So, and in addition, of the 19 member states in Europe allowing registered partnership, only 2 exclude same-sex couples from registered partnership. That was Greece and Lithuania. And so the court, what do you guess the court said? The court said, if you remember what I told you, that the state is obliged to put forward convincing and weighty reasons, particularly serious reasons, why it is necessary to make this distinction. And the burden of proof is on the state. And the court came to the conclusion there are no convincing and weighty reasons capable to justify the exclusion of same-sex couples. In especially as the Greek government relied on regulations on children, biological children of a couple, and then the court said, well, you can make certain provisions on this, but that does not allow or justify to withhold the whole institution from same-sex couples. So if registered partnership is not allowed to discriminate on the basis of sexual orientation, and if registered partnership, civil unions have to be open for all, why should then not be civil marriage? We always have to remember that when we talk about same-sex marriage in this context, it's not about religious marriage, that's most important. It's always about civil marriage, state marriage, and not about marriage by religious communities, which are a total different issue. So why should the state be obliged to perform registered partnerships for all kinds of sexual orientations and gender combinations of partners and not civil marriage, especially as the court made all the statements in the transsexual marriage cases. So at least I myself hope that this is a further step towards the court someday finding also the prohibition of same-sex marriage in violation of the convention, but that will still last some years. But I hope that I will see it some days, and that's how I conclude my presentation. Thank you very much. Just in here.
I'll speak from here. Thank you, Helmut, for a very illuminating tour of recent jurisprudence of the European Court. The way we're going to proceed here is that we're going to hold off questions and discussion until the very end of the panel, because I imagine that many of the questions are going to be ones that multiple panelists may choose to answer or respond to. With that, let us turn to our next speaker, who has also worked very extensively on questions of marital law, who's an expert in family law, and that's Professor Rosemary Auchmuty of the University of Reading in the UK. And as you know, the UK has also recently, with support of all major political parties, sanctioned same-sex marriage. But Rosemary comes from the perspective of someone who has some doubts about the institution of marriage and whether that's something that really advantages same-sex couples.
I'm looking for this this document, which is called Three Cheers. Three Cheers.
She has many accomplishments.
Not doing computers, that's for sure. Three Cheers.
It's not one of my areas of
it's
great
crossed.
competence either.
But
Actually, prior to receiving her law degree, she did a doctorate in history and was particularly interested in women's history of the Victorian period, has written a great deal on children's literature, and I think that she shows that there is life even after a humanities PhD, which is a welcome lesson to any of us. So, Rosemary, are we ready to go?
thank you, Thomas. Thank you. I'm
Good.
sorry I took so long to find this presentation. Right, okay. So just a little bit about the situation around same-sex marriage in England, which is interesting, I think, because Helmut was talking about registered partnerships. We had the Civil Partnership Act in 2004, which came into force in December 2005. And just to explain that the Civil Partnership Act actually gives the same rights to same-sex couples as marriage, with very small number of differences. The most important one, oddly enough, being that one of the 5 grounds for divorce, which is available for heterosexuals who are getting divorced, is not available to same-sex couples who are dissolving, as we say, a civil partnership, and that's adultery. And this was because, well, there are possibly 2 reasons, but one of them was certainly that the legislature, the government, was not really anxious to try and define what adultery might be in the same-sex situation. We're quite unusual, I think, in that we still have a fault-based divorce system. So that was one, and you also can't annul a civil partnership for non-consummation for the same reason. But in other respects, with just a couple of differences around children, which are just basically because in heterosexual marriage, the father is the legal, the husband is the legal father, and you can't have that same situation with civil partners. However, a civil partner can now be named on a birth certificate as a second parent. But those slight differences, in every other respect, civil partnership and same-sex marriage are the same. And the dissolution process is the same. But because they don't have the name, and of course that was a political decision to appease the churches, there, I think, has always been a little bit of confusion amongst people, even those who've registered civil partnerships, and who quite freely talk about having got married and having weddings and so on. There's still a little bit of confusion where they don't quite believe it is the same as marriage. And this particularly arises, and this is what this presentation is about really, on dissolution, when the relationship comes to an end, because I've done a little research I'm going to tell you about when I've gone through all of this. So just to explain then that we have this civil partnership. Registrations, many more than were predicted. Of course, they had no idea how many people were going to, they had no idea how many gays and lesbians there were in the country, and I think they were a bit surprised how popular it was. What was very striking was, in the beginning, twice as many men registered civil partnerships, right up to this year, well, this last year. We don't have figures for this year, but for 2012, when for the first time women started to register as many as men, or slightly more, in fact. And that's very interesting, and it's one of the issues that I've been in conversation with the National Office for Statistics about why this might be the case. And I think it's fairly easy to see that in the beginning, the reason why there were more men was because of the financial reasons for getting married. And men, there are a lot of older men, obviously, who'd been in relationships for a very long time, for whom it was financially advantageous to get married. Less so for women, I think, but I think also probably a bit more skepticism from women about the advantages of marriage. Anyway, we'll come on to that in a minute. Dissolutions then. There have been 2,500 dissolutions since the process became available, which was in January 2007. In England, you have to be married for a year before you can get divorced. Interestingly, in view of the fact that many more men have registered civil partnerships, women are twice as likely to dissolve them, but the men are beginning to catch up, we're beginning to see more parity there. And again, I have an explanation for that, which I'll talk about later. But what is interesting is that you are more likely to divorce as a heterosexual couple in the first 4 years of your marriage than you are to dissolve your civil partnership. So much for the instability of same-sex relationships. It's clear that they're actually more stable than people imagined, and certainly more stable than in the early years than marriage. But of course, everyone's looking at the statistics after 7 years, because 7 years is the time when married couples are supposed normally to have the 7-year itch and start parting. Okay, the new legislation then in July this year, our Conservative government got through after some resistance from their own party mainly, the Married Same-Sex Couples Act. And it'll take a while for them to get the regulations through, so it probably won't come into force until next year. The thing that most people don't understand is that what the form that same-sex marriage takes in England, and note, by the way, I'm talking about England rather than the UK. This is because the UK consists of several different countries with different legal systems, in fact. On the international stage, of course, they operate as the UK, but this act, I think, only applies to England and Wales. And that is often the case. I mean, sometimes there's a separate one for Scotland, which has a civil law tradition, not a common law tradition, Scotland, but might share this sort of thing. But I think this one is England and Wales. Anyway, the thing about same-sex marriage is it's identical with a civil partnership. Okay, apart from this one thing that they did bring in, which is the possibility that it can now, instead of just having to be civil, it can now be celebrated in participating churches. The point about the old civil partnership was that it could only be done in a registry office. Of course, marriages can be celebrated in a whole range of churches, which are accepted as, it's not a separate ceremony as it is, I think, in some continental countries. It's all done in the church. Now, of course, most of the major churches don't participate. It doesn't include the Church of England, doesn't include the Roman Catholic Church, doesn't include Islam, for example. They don't recognize same-sex marriage. But there will be some churches which will do this. But in other respects, in the legal respects, what we've got is a civil partnership or same-sex marriage, and people will be able to choose. Same-sex couples will be able to choose. The huge irony, of course, is that heterosexuals don't have this choice in England. They can only get married. And so we do have a movement amongst heterosexuals to be able to have a civil partnership. Now, legally, they're really no different, apart from the adultery ground. But of course, there are people who don't like the connotations of marriage, heterosexual couples who are very resistant to perhaps the religious connotations or other, the history of marriage, and would like to have a recognized legal status, but want to call it a civil partnership. But in fact, they're all much the same. But as I said, we do have this irony. I don't know if anyone imagined they probably will they will litigate this under the European Convention, because here are these poor heterosexuals with only one choice and the gays and lesbians with two. That does sound discriminatory. Okay, so I have explained then that. Divorce and dissolution then, the process, it's identical for both the civil partnership and marriage, except for the adultery ground, as I said, which exists for heterosexual marriage. There are 5 grounds or 4 grounds, which are things like unreasonable behaviour, which is the most common one, and separation with consent, separation without consent, and so on. Anyway, property division and arrangements for children have to be approved by the court. So if you dissolve your civil partnership, as if you get divorced, you do have to organise both these things, and that might include, for example, that some property is transferred from one spouse to the other, or that there's some arrangements are made for some kind of maintenance, and obviously arrangements for the children. I mean, that's fairly standard, and we all understand that in the context of divorce. And if there's a dispute, of course, then a judge will be involved, and if there's a dispute, then a judge will decide, and there's a discretion as to how the property is awarded. Now, I'm making a point about this, which I think we probably all know, because when I came to do my research, and I actually interviewed a number of people who had dissolved their civil partnerships, it was fairly clear that they hadn't realised that this was the case. Right, I just want to make another point then. Getting on to marriage then. What is so interesting about all this agitation for the right to marry, which of course everyone must agree is a right that same-sex couples should have, is that marriage is in decline, has been in decline all over the Western world for the last 50 years. In other words, gays and lesbians are really sort of shrieking to join what many might think is a sinking ship. And I've given you some statistics here. I just chose these for the UK and the USA for obvious reasons. And France, I also teach in France. And of course, the French also have also just legislated for same-sex marriage about the same time, almost at the identical time that the British government did this year, and Germany. And what you'll see, if you have a look there, you'll see the huge decline there has been over the last 50 years in the marriage rate. It's in the UK, as also in the USA and France, the peak is around 1970. In the UK, we had divorce law reform then, and that actually freed up a lot of people to remarry. But what happened almost instantly is that marriage was not taken as seriously anymore. A lot of people got divorced but didn't bother with the marriage and so on. And you see this, that we're now down to much lower figures. The French really much lower, the Germans too. Sort of half, the rate is half what it was 50 years ago. So we're in a period of marriage decline for a whole range of reasons, some of which I posit here, and this is something that I've written about. But I think really one of the really important ones has been the change in women's situation across this period, which of course mirrors my own life, and I lived through it. When I was growing up, there really was no other goal for women but to marry. You might do something else, but I mean, it would be a disaster if you didn't get married. And everything really, your whole sort of future, your education, the kinds of decisions you made about the jobs you did, the kinds of jobs that were available, the pay that you got once you got into your job, all of this was premised on the notion that you would, as a woman, get married. And of course, give up work either on marriage in the 50s or in the 60s when you had your first child. That if you did go back to work, it would be part-time, pocket money to fit around your childcare. You'd be enhancing your husband's career. That's really what you were being educated for. And everything changed really in the 60s when the economy changed, when there was much more move, I think probably across the Western world to educate women, when certainly in the UK. I mean, I grew up in Australia, but it was the same there. The universities expanded, that many more women went to university. There was a real need for an educated workforce. And then, of course, in the 70s, we have the women's movement. You have the equal pay. You get the beginnings of anti-discrimination legislation and so on. It was the same, I think, in most countries. That shifted everything, really. And for the first time, really, it became possible for women to choose. They didn't have to marry. I mean, you could marry. Most people did marry, but it wasn't the only thing you did. It was no longer an economic necessity, in fact. And as I've also made the point, it could be an economic burden, because now certainly it is the case that if women are in a senior position and take up with a partner who's less well off, the burdens, the legal bonds of marriage oblige you to maintain your partner. And I remember I was at a conference, an American conference, as a matter of fact, where an American law professor said she had been discussing with her hairdresser the issue of marriage, and her hairdresser said, "Look, you know, I can afford to keep myself. I can afford to keep myself and the kid, but I can't afford to keep myself, the kid, and him." And for that reason, she wasn't going to get married. And so I think it's really interesting that it's at both ends of the spectrum. We've had a lot of cases recently in the UK of rich women or better off women, and the litigants, the person who's going to court to try and get a share, to try and undo a prenuptial agreement in one case, or in case of unmarried couples to get a better share of the home. There have been men who've been doing this. It's actually the women who are in the stronger position. So, of course, that has all changed in my lifetime. So anyway, I've suggested some other things here, reasons why people have decided not to get married or don't get round to getting married or putting it off until they've got enough money or whatever. But certainly, I think all of these are really interesting now that same-sex couples are in the same position of having to consider for the first time in the last 10 years, actually consider the possibility that they too could get married. I think it's probably worth considering the economic side, which is what I'm focusing on here. I've listed a few other things here too. The feminist critique, which was a powerful thing certainly for me. If you look at the history of marriage, it's never been good for women historically. So, you know, it does tend to colour your view of it. If you just consider, you know, domestic violence being privatised, well, that's just something that happens in the home, we won't intervene, all that sort of thing. And the resistance to state intervention, because people tend to forget, but when you get married, that actually means you invite the state into your bedroom. Again, something new for gays and lesbians. Well, it's not as though the state hadn't been in their bedroom, of course, in being terribly interested in their lives, but it's in a different way. It's in a different way now. Okay, so I did this research, as I said, and what I wanted to do was, for the first time, to actually have a look at what it was like to dissolve a civil partnership and what people thought about it. And I was particularly interested in what my interviewees understood at the time of registering it, that civil partnership meant to them, why they did it, and particularly what they thought of the legal consequences. And dissolution, if they thought of it. Of course, it's very, very difficult when you are getting married to think about the possibility of ever ending. Although my brother, who is American, who lives in Houston, he said to me, Texas people always think about the financial situation. And I guess that makes it's probably true, but it's different in the UK, as you will find. Anyway, my hypothesis was that many same-sex couples would have registered the civil partnership without understanding the legal and financial consequences or contemplating the possibility of dissolution. And I did this because at the time that the civil partnerships came in and at the time that people were talking about same-sex marriage, I actually looked at the kind of literature and the publicity that was coming around, including from the gay lobby. And it was all positive and about equality, all the good things, and there was nothing that would have helped at the financial level, or if there was anything, it was really misleading stuff. Anyway, this is what I found that people had chosen to marry, or the arguments that I saw in the press for same-sex marriage or registering a civil partnership. The biggest one that my interviewees came out with, particularly the older ones, was, you know, we're going to do it for because it's legal recognition, because it's equality. We want to stand up and be counted. We want people to see that there are, you know, couples like us. So it was a really important equality gesture for them. But the second biggest one, again, particularly for the older ones, but also the younger ones, was that they thought that there were legal and financial protections that attached to marriage. And this is really interesting because it's true also of married people. They're very vague about these. Now, the particular law that attaches to marriage, although we all talk about marriage and we all understand it from our own different perspectives, the law in every different country is different. Marriage means something quite different actually here than it does in the UK. I think a lot of people, one of the big financial pulls for marriage here must surely be your healthcare, your transferable healthcare. in the UK, we have a national health service, so no one gets married to get healthcare benefits from their partner. That is never an issue. Some countries would have tax advantages, for example. Some people think that it's very important to have a blood relative or a spouse as your next of kin. And because, you know, we live in a global world, we hear all this stuff. We get a lot of stuff from America, and people think that it's like that in England, and it isn't necessarily. So, for example, people said, well, I want to be able to name my partner as next of kin so that if I'm in hospital, if I have to go into an old folks' home, whatever it is, you know, they can make the decision and the family can't come in and contradict them. What they don't know is that in England, actually, I don't know how it is here, but next of kin has no legal meaning at all. You can actually nominate anyone as your next of kin. You don't actually have to be married, and in fact, you could nominate your partner and it would be recognised. But of course, you know, there could be disputes in the hospital if you're unconscious and so on. So you can see why people do it, but it wasn't probably legally necessary to do it. There are almost no tax advantages to marry anymore. The reason for this, of course, is because the tax system has adjusted to the fact that people aren't getting married, and so if you only tax, you know, they have to tax everyone basically. So they've levelled off all the taxes. The Tory government has just introduced the most bizarre tax credit that's available to some married couples if one of them is a basic rate taxpayer. It's terribly complicated, and it really only applies to very few people and amounts to about £100 a year. And so no one thinks much of it. There is an inheritance tax benefit, which is that if you pass we have inheritance tax in England, and if someone dies, they'll be taxed on their estate. But if you leave your estate to your spouse, they're not going to be taxed. But what people don't realise is it's only very rich people who pay inheritance tax. So lots of people think, oh, goodness, you know, we've got this house. I don't want to have to sell the house, so I'll get married. So there were a lot of misconceptions around there. Transferable pension rights, these have been extended too to almost all pensions. Certainly all public pensions, insofar as we have any anymore, you actually can nominate your unmarried partner now. But a lot of people thought, oh, you have to be married for that. Anyway, so these legal and financial protections are important. Now, the third argument that there was for same-sex marriage was this argument, which is a kind of a radical or progressive argument, that we will show the world how a truly egalitarian relationship can be. Because we don't have this gendered power difference, we don't have, you know, men oppressing women, as it were, but we have equals, we're the same sex, that this actually is a really important gesture, and we could transform the idea of marriage. Right, on to what I found then, because this was so interesting to me. And these are just a few quotes, which I'll show you to see the results. So first of all, did anyone think about dissolution? No, said one of mine. It didn't cross our minds at all. It was simply, yes, tying the knot with what was already existing. I had no imagination at all that it would come to an end. Now, these people that I was interviewing here were people who'd perhaps been together for 10, 20 years. And at last they were able to register, they were able to marry, as it were. And so they thought, right, well, you know, we've been together forever, we're now going to do it. We're going now. And it never occurred to them, but they'd been together for so long that they would break up. And the second one here, I never looked at the dissolution. I knew vaguely it was the same as divorce, but not entirely what that meant. So one of my concerns was, would I have to pay my ex-partner? I think the Americans call it alimony. I was surprised that that actually was there, and that there was a possibility she could claim for that. So we're beginning to see this idea that people had not realised that what they were doing was not just making a gesture and getting equality. They were actually putting themselves into a legal relationship where, on the dissolution, the court could transfer the property between them. And it's true that, and it's quite clear that property is key. The older ones said, and that's the thing, it comes down to, you know, money and stuff. I'd never ever imagined it would be. It would. But then I did interview some other people who didn't have any. Actually, the younger ones often had assets too, but one person I interviewed said, oh, ours was fairly easy. We didn't own any property together. It was just a piece of paper. And I think that's probably true, that if you divorce or dissolve, and you don't have children, you don't have property, then this is not really a problem. Now, this one was a woman who'd been in her relationship. They'd been together for 27 years. They got married on the very first day that the Civil Partnership Act became available. They had a huge party here and actually in England and in the States because they were quite well known. Now, before then, they had owned several houses together and they'd borrowed and lent money from each other and so on. So they had a document, this is before civil partnerships came in, they had a document, a legal document, which was very clear about how we paid for things, how things were going to be separated. And she says it was a very good attempt by a lawyer at the time when there were no legal rights to get as close as we could to having an unbreakable agreement. And then she says, but of course the minute her partner, went to a lawyer, they told her she could get half because she was married to me. And of course the length of the relationship did suggest, and she was saying, did suggest she was dependent. And she was completely astonished and outraged. I mean, she was annoyed enough about her partner going off. But actually, that there's these agreements that they'd had, because this lawyer had got involved and said, oh, you can get more than that, she was actually going to lose some of her property. On the other side, we have someone who had nothing. She was an artist who'd taken up with a university professor. And she said, at first I just thought, everything's hers, I have to go. But the more I think about it, and the more people talk to me about it, I think, actually, we had a future plan together and we made plans together. We kind of worked towards it together. You're the one who's much better off. I need to start my life now, again, somewhere else. You, as the person who's decided that you no longer want that contract in the same way, need to give me something to help me out. So here we're getting the other side of the picture. And I just want to mention, because I didn't mention it before, we don't have community of property in England. So it's not half each. People may think they get half, but that is not actually the law. There's complete discretion as to how divorce settlements are. And although there is an assumption that you will start from 50-50, it's very quickly adjusted and very few people do end up with 50-50. But in this case, this is a woman who had nothing, but will eventually get something. So my hypothesis then, was I right? I certainly found many older people who'd welcomed the Civil Partnership Act for conferring equality on gays and lesbians, who did not understand what the entry of the law into their relationships meant in terms of division of property on dissolution. And this woman said, you know, I'm reasonably legally oriented, reasonably corporately orientated. And my ex and I had spent many years actually campaigning for this, for same-sex marriage. And she says, so if we didn't understand it, I think no one understood it. So, another one said, what was wrong with it was that the lawyers and the judge, this one actually went to court, where she had a black woman judge, and they both had gay lawyers, gay male lawyers. And she said, but she was very angry with the settlement because she said, because the lawyers are basing it on heterosexual law rather than, you know, homosexual law. There's a different understanding of finances. When we were together, you know, 25 years ago, we always kept separate finances. We even bought separate items of furniture because there was always the understanding that what was yours is yours and what was yours is yours. What the law did was to go, what's yours is mine and what's mine is my own, and that's what they used to get their pound of flesh. And I think what's so interesting about this quote is you can feel her anger actually here. However, I think things are changing. Younger women are now entering the institution in greater numbers. They don't have the old politics of feminism or the politics of the sort of gay liberation movement either. It's just kind of normal for them. They don't have the experience of marriage. I mean, many of my interviewees were lesbians or indeed gay men, but they had been married, heterosexually married before. So, you know, these young people don't have that either to put them off marriage. And I think this is why we're getting equal numbers of men and women now registering and equal numbers dissolving, because there's with the younger people, I don't know how it is with you young people here, but much more this idea that it's normal and, you know, we're getting married. They used to have they all talked about their big white weddings in a way the older people didn't do. The older people just, went away into a registry office and got married and then maybe had a party. But these ones would have these huge white weddings with bridesmaids and everything and all the family involved and so on. And they always used the word marriage. And of course, there's a powerful marriage industry, there's fashion and so on. But what goes hand in hand with that is they're actually much more realistic about the idea of divorce, because we all know that, it's certainly in the UK, 40% of marriages end in divorce. It's probably similar here. And here, M was a young man, and he said, I don't think anyone who enters into marriage or civil partnership actually in this day and age necessarily expects it's going to be forever. Whereas, of course, many of my interviewees had been together for 20 years and did think it was going to be forever. And I think this then accounts for the gender convergence in dissolutions. So my predictions for the future. I've already explained how marriage is declining. And I had a look at the Canadian figures, by the way, because, of course, they've had same-sex marriage for quite a long time. It's still declining, even with the addition of the same-sex couples, though perhaps not as fast. So anyway, I think because more marriages currently end in divorce than civil partnerships and dissolution so far, I like to do this because then in 10 years' time I do some more research and see if I was right. I predict an increase in dissolution as younger people register and dissolve civil partnerships, same-sex marriages we now have, in the same spirit as younger heterosexuals enter and leave marriage. In other words, it's no longer going to be this terrific equality gain, this thing that is so important because it's been denied for so long. They don't have that history or that memory. It's just marriage like anyone else, and they don't work out, and that's it. And I think this will be true particularly now that civil partners, there was all this doubt about what a civil partnership was. There can't be any doubt about what same-sex marriage is. And then I just have this concluding sentence: with marriage in overall decline, will the addition of gay and lesbian couples be enough to save it? Thanks.
Thank you, Rosemary. That was very clear and gives us food for thought. Our next speaker is going to give us a local perspective, because part of the purpose of this conference is not just for the Europeans to teach us about the examples of legal evolution in their country, but also for us to tell them some things about what's going on here in Texas. And for that, I've chosen a very well-qualified person, Daniel Williams, who is the legislative liaison, the lobbyist, in effect, for our local Texan gay rights organization, Equality Texas. And, of course, we usually don't think of Texas as being a very hospitable place for gay and lesbian rights, but nevertheless, there have been some incremental changes and small victories, and we hope more, but Daniel will tell us.
Thank you, and thank you very much for inviting me here today. I want to start off by saying I am not a legal scholar. I am a political strategist and a legislative analyst, and so I do approach these topics from a different angle. I am from Houston, Texas, which for our European guest is basically equivalent to 2 countries away. It's 180 miles. I wanted to talk today about specifically the freedom of marry and the evolution of the freedom of marry in Texas between 1997 and 2013, and you'll understand in a moment why I'm starting with 1997. But before we get to 97, some context. Texas is currently operating under the Constitution of 1876, which says absolutely nothing about whether or not 2 men or 2 women can get married. Now, the Penal Code adopted shortly after that did make sodomy a felony. That law remained in effect. In 1971, the Texas legislature actually revised the Penal Code completely and removed that crime. However, their revisions were vetoed by the governor specifically because it removed the crime of sodomy from the law. And so the compromise in 1973 was to substitute the felony of sodomy for the misdemeanor of homosexual conduct, which I've always questioned exactly what homosexual conduct means. Is that putting up mauve drapes or something similar? In the early 80s, Texas courts found that state universities could not refuse to recognize a student club simply because it was organized around the gay and lesbian community. In 1981, Houston finally revoked its law against cross-dressing. In the early 90s, the courts found that Texas cities and police departments could not specifically refuse to employ gays and lesbians. So heading into the context of 1997, homosexual conduct is illegal in the state of Texas. However, universities, cities, and as would later be argued, the state, although that's still in somewhat debate, may not discriminate in employment against people because of their sexual orientation. Oops, that is not the button to push to go to the next slide. That is. So, in 1997, what did Texas law have to say about the freedom of two people of the same sex to wed? Absolutely nothing. There was nothing on the books at the beginning of 1997. Now, that's the same year that the state of Hawaii began their legal challenges looking at the right, and that institutes a panic. By some people. There is an attempt in the legislature to modify the statute to prohibit the freedom to marry. It was not successful. However, the Department of State Health Services issued an administrative ruling in 1997 saying that the state would not accept applications to marry from two people of the same sex, nor would they recognize marriage from any same-sex marriage from any other state. Now, this is, of course, before any other state actually has same-sex marriage. But the Department of State Health Services is on the job and preemptively rules that that will not be allowed. 1999, it's a little intimidating talking about this case with Judge Fry in the room, since this is really her area of expertise. This is the first time Texas courts really get an opportunity to look at this question. And the case came out of San Antonio, involved Christy Lee Littleton, who was a woman with a history of gender transition. Her husband went into the hospital, passed away, and she attempted to sue for medical malpractice. The hospital, or more accurately, the insurance company, argued to the court that because Christy was originally identified as male on her birth certificate, her marriage was therefore a same-sex marriage not recognized by the laws of the state of Texas, and that she therefore did not have standing to sue for medical malpractice. The courts agreed in a bizarre way. The judge in the case took a look at the case law, for which there was almost none at that time in the state of Texas. There was a few other U.S. cases, but the case law he really settled on was a 20-year-old British case, Corbet v. Corbet, and which argued that for the purposes of marriage, genetic sex, and that's the term that's used in the ruling, genetic sex, determined whether or not a person was male or female. Now, the use of the term genetic sex is interesting since the court actually conducted no genetic testing. There's an assumption made on the part of the judge that the gender marker on a birth certificate was, in fact, genetic sex. That was never actually backed up by any evidence seen by either the trial or appellate court. This case is actually currently being challenged, and we will talk about that a little bit more. But this is really the first chance the courts got to take a look at this question in the state of Texas. And at the time they were taking a look at this question, there was no standardized process for changing gender markers in the state of Texas, which there still is not. And the only prohibition against same-sex marriage would be that administrative ruling by the Department of State Health Services. 2003. After about 10 years of trying, a statutory revision finally goes through prohibiting the state of Texas from recognizing a marriage between persons of the same sex or a civil union, which is saying that it's contrary to the public policy of the state and is void in this state. Now that law passes the Texas House 79% to 6% effectively. I did not put the Senate numbers up here for various reasons. Senate votes in the state of Texas get a little bit wonky, and the actual breakdown of the votes isn't terribly instructive. But in this case, it's the first time we get a look at what a representative body for the people of the state of Texas thinks about this issue. And we get 79 to 6%. 2004 is the first time we see any public polling in the state of Texas about what the people of the state of Texas think. Source here is the Williams Institute, and they were looking at Texans over the age of 18. So this is not registered voters, this is not likely voters, this is simply adults in the state of Texas. And in 2004, 24% of adult Texas support what was asked in the polling as gay marriage, which is about what we saw the next year when the issue got put on the ballot. In fact, it's exactly what we saw the next year when the issue got put on the ballot. In 2005, after about a decade of trying, a constitutional amendment passed the legislature and was put to the people of the state of Texas. This is Prop 2, which forbids the state or any entity within the state, specifically looking at taxing entities such as hospital district, municipalities, counties, from recognizing marriage between two people of the same legally recognized sex. It does pass on a public vote 76 to 24. And that 24% becomes our baseline. It's the first good numbers, both the 04 polling and the ballot initiative in 05 put support for that idea at 24%. Now, an important thing to note is that what was on the ballot in 05 was banning both civil unions and marriage. We're looking at an absolute prohibition against any form of legal recognition in the state of Texas. And we get 76% of voters supporting that idea. 2010 is the next time we get any good polling data. This is from the University of Texas, Texas Tribune poll. And the bottom darker blue you see there is support for marriage. The lighter blue is support for marriage or, bottom blue, the dark blue is support for marriage or civil unions. The light blue is support for civil unions only. The dark red is support for neither, no form of legal recognition. And then the pink is undecided. And you can see there's decided trending upward in the state of Texas. That little by little increased support. And this polling is looking at, adults, again, adult Texans. So from February of 2010 to June of 2013, support for marriage in the state of Texas went up from 11%, from 28% to 39%. So 24% in 04, 28% in 2010, 39% in 2013. That is pretty precipitous change in public opinion over a period of less than a decade. Support for some form of legal recognition goes up from 63 to 69%. Now, some of what you're seeing there is that, a significant amount of the increase in support for marriage is people who previously supported civil unions going whole hog. Similar numbers here from public policy polling. Their support is a little bit lower, but their general trending is similar. I tend to think public policy polling's numbers are on the low side. In part, their earliest numbers come from September of 2011 when they're showing 24% support for marriage. I find it hard to believe that there was absolutely no movement between 04 and 2011. So I suspect that their polling numbers are skewing slightly low. They are, public policy looks at registered voters. Which also might explain, public policy looks at adults as well. So this is adult Texans. Similar movement, but slightly less support, going from 24% support for marriage to 59% support for some form of recognition during that, 29%, that's a typo. 31% for marriage to 63% for some form of recognition in that same time period. Now here's where things get interesting. All of that polling data to date has been adults in the state of Texas. When you start looking at actual voters, the numbers get very, very different. We commissioned the Glenn Gariff group to do polling in 2010 and 2013. looking at registered voters who had a history of voting in the state of Texas within the last 2 years. Those numbers are remarkably different. In 2010, we found 43% of voters in the state of Texas supported the right to marry, of same-sex couples to be married. And that in the 3-year time span between the two data sets, that increased 5% to 48%. So adult support is lagging behind voter support, people who actually wind up at the polls. If we compare this to the 05 ballot initiative, which had 24% support, if we count that as voters, what we're looking at is an almost doubling of public support within a period of 8 years, which is hopeful and very significant. However, bad news. Most of the increases come from demographic shifts within the state of Texas. Texas is increasingly younger over the last 8 years. At the 05 ballot initiative, the only age demographic that voted in a majority in support of marriage was the 18 to 24 demographic. Now that was 8 years ago, so they are now 26 to 32, and they have continued their support. They're added are that new younger generation, which actually supports marriage at a much higher rate. However, that older demographic, their opposition remains about even. It's decreased slightly, but only very slightly and within the margin of error. And it's simply by dying off that demographic has dropped off of the larger polling. African Americans and Hispanic Texans support the freedom to marry at levels much higher than their white counterparts. And as the state becomes increasingly black, and especially as the state becomes increasingly Hispanic, those demographic increases have affected the overall support in the state of Texas. Additionally, Texas is increasingly an urban state, and the majority of that urban growth has come from people born outside of the state. Non-native Texans support the freedom to marry at much higher rates. So the question then is, if the people who opposed marriage in 04 are still opposing marriage, and the people who are supporting marriage now are new. They're young, they're recently here. What can be done to talk to and persuade the people who have been in opposition the whole time? Because we're not changing minds, the numbers are changing because new people are showing up. I'm very excited Equality Texas will launch next year in partnership with the National Organization Freedom to Marry a project called Marriage Matters Texas, where we will undertake to change hearts and minds in the state of Texas. One of the things we've seen in states that have successfully passed the freedom to marry is the change in public opinion comes not from arguments about justice or arguments about doing the right thing, but rather talking to people about everyday lives. And there's some wonderful polling that was done out of Oregon. Probably not polling, they did focus groups. And they asked the group, why do people like, this is a group of heterosexuals, why do people like you want to get married? And the answers they got were to build a life together, to have children, because they love each other, for religious recognition. When they asked that same group, why do gays and lesbians want to get married? The answers they got were for legal rights, for hospital visitation, for inheritance. And as long as the people in opposition think that gays, LGBT people want to get married for different reasons, efforts to persuade the general population are never going to be successful. So our public messaging over the next few years will be focused on that hearts and minds work of telling personal stories to the population about things like fighting over who has to load the dishwasher and deciding which house to buy. There are currently several challenges in Texas courts There are two lawsuits, very different lawsuits, interesting, over divorce that are currently before the Texas Supreme Court. One out of Dallas and one out of Austin. In the Dallas case, the trial court found that insofar as it applies to divorce, the statutory and constitutional bans against recognizing same-sex relationships were unconstitutional, so invalidating the statute. In the Austin case, and I love this decision, law students in the room, if you've got some spare time and want to read a bit of brilliant legal opinions, check out this case out of Austin. It's out of the, First Court of Appeals. Third Court of Appeals. Said that divorce is not a right that extends from marriage when you read the Texas statute. In fact, there's nothing in the Texas statute around divorce that says one has to be married to get divorced. The requirement for getting a divorce in the state of Texas is that you must be a resident of the state of Texas. And that therefore divorce is a right conveyed by residency, not by the recognition of a marriage. And it managed to avoid invalidating the statute by that brilliant bit of reasoning. The Attorney General office did not agree with that bit of reasoning, and after several attempts was able to get the case before the Supreme Court. Both of those were recently heard, and we are awaiting an opinion on that matter. There was also recently a federal suit filed in the city of San Antonio that is an equal protection claim based largely on the Supreme Court's findings from this last June. Additionally, and I didn't get this up here, but I did want to mention Delgado v. Aragoose, which is a challenge to that Littleton case from 1999 that I mentioned earlier. In 2009, Equality Texas, along with our allies in the Texas legislature, were able to sneak 3 words into the Texas Family Code. Until 2009, in order to get a marriage license, you had to bring a birth certificate to the court when you're applying for a marriage license, and there was a reason to revise that to allow people to bring other forms of ID, such as a driver's license. People were very upset they were getting turned away from the county clerk's office when they wanted a marriage license. During that debate, which got rather insane for a number of reasons, we were able to have an ally sneak in among the documents that can be used to identify oneself to get a marriage license, a court-ordered change of sex. This is the first recognition in Texas statute of the court's ability to order a change of those identity documents. And because it can be used to establish identity to obtain a marriage license, there is very good legal reasoning to suggest that therefore someone who has a history of gender transition can obtain a marriage license. And since the state of Texas does not recognize marriages between 2 people of the same sex, that it must therefore only apply to a person with a history of gender transition marrying someone of the opposite legally recognized sex. That is the question that is before the court currently in the Aragoose case. It is on appeal, and we are waiting for an opinion. I also wanted to mention this Wednesday, as in just a couple days ago, the city of Houston announced that it would begin to recognize all marriages for providing benefits to city employees, including out-of-state same-sex marriages. The city attorney feels that the Supreme Court's decision in Windsor requires the city to do so. It is in direct conflict with both statutory and constitutional prohibition in the state of Texas. The Attorney General has not filed to intervene as of a few hours ago. It could have happened an hour ago and I would have missed it. But that filing will undoubtedly come very, very soon. So that's 5 cases in the Texas courts currently challenging various aspects of this law as public opinion continues to develop. Thank you very much.
Thank you. That was fascinating and certainly gives us some grounds for encouragement. Our next speaker, Billy, we need you to help with the Skype connection. Our next speaker is Yasmin Nair. who is a blogger and activist and opinionated person. Who always has something interesting to say. She is involved with an organization called Against Equality. And she has a more, albeit from the standpoint of being a queer activist, she has a standpoint that questions some of the assumptions about whether marriage should really be the focus of lobbying and activism. So we certainly want to hear that side of the debate as well, and Yasmin will now bring that to us. Yasmin.
Yes, thank you. Shut this off. So. Thank you very much. Let me know if the sound at any point having thought and but listening. I probably do anyway. But thank you to everyone, particularly to Tom for arranging my appearance here today. I'm also to be honored to be part of this panel. And I think at least one of my friends is in the audience, Ali. So, hi, Ali. So my talk today is titled Neoliberalism and Gay Marriage. And I think it should probably be subtitled Are We All Edith Windsor-Yad? The talk today is going to, in essence, connect the dots between the rise of neoliberalism in the United States and the rise of gay marriage. I define neoliberalism as the intense, and this is very, of course, very, very short version. I define neoliberalism as the intense privatization of everyday life and the formation of the state, which increasingly places the burden of care upon the family unit, upon privatized units, as opposed to the state itself. And again, it's very broad, just a very quick definition. In order to do all this, I will be situating gay marriage within an economic context, with particular emphasis on Edith Windsor, the plaintiff and part of the recent Defense of Marriage Act. What I want to do in all of this is to begin to construct, and this is all very sort of moving towards a larger project, is to begin to construct a brief history of how gay marriage came to be the cause of the gay movement. And it's a history that is effectively made invisible in the discourse around marriage as an issue of political boycott. So let me begin first with a description of why I use the term gay marriage rather than freedom to marry or marriage equality or same-sex marriage. As many of you probably know, that's been the topic of much discussion for a long time. And just to quote, if you will, if I quote myself from a recent article in Chicago Reader, the term marriage equality includes the fact that the institution many gays and lesbians, whereby at least the majority of them clamor for, is in fact embedded in a long history of sexism, misogyny, and racism, which defines people, and particularly women and children, as objects of possession. Even more importantly, marriage is part of the larger neoliberal enterprise, a greater system of privatization, a state of things where people increasingly must enter into private contracts like marriage in order to gain the most basic benefits, like healthcare, the ability to decide who can receive their estates, small or large, upon death. So in using terms like same-sex marriage, marriage equality, or equal marriage, gay marriage undergoes attempted divorce, as it were. The word marriage focuses largely on longer-term history, and instead render marriage an elemental, primordial, deep-rooted, almost genetic need to couple up, rather than what it is, which is a socially constructed institution. So the hoopla around marriage has intensified over the last decade or so, as we all know, and which is interesting because, as has already been pointed out in the British context, marriage rates are actually falling quite a lot in the US as well. And yet, paradoxically, marriage is now very big business. There are, as we speak, of course, innumerable shows about wedding planning, bridal gowns. The marriage industry has effectively risen from the ashes of marriage itself. So consider, for instance, the fact that American defense marriages declined in the last 2 decades it makes it less interesting. The problem with gay marriage in the United States is that it is part of the machinery of neoliberalism, and that it functions both to effectively end the state's interest in maintaining the well-being of people and to increase the power of a wealthy elite. Barring a few exceptions, queer theorists have tended to ignore the economic qualifications of gay marriage. Even when they do, the discussions tend to be the more bland argument that we need to move, quote-unquote, beyond marriage. And I should confess, first of all, that I was at one time part of the camp. They also have a tendency to situate their critiques in terms of marriage as part of a trend towards assimilation. A critique that, of course, as has already been noted, is rooted in early liberation. I want to make it clear, because I think we really something, a couple of things, because I think that as we move towards the critique of marriage in the context of neoliberalism, it's really important to understand where some of this don't come from. I want to make it clear from the start that both these analyses fail to get at the bigger problems with marriage. So first, if we have to combat neoliberalism, we need to end the institutions that make it stronger. In the US, unlike countries like Canada or Sweden, marriage is all that guarantee myriad of life-saving benefits, including healthcare and immigration status. So when I call for an end to marriage, what I'm calling for really is what I'm saying really insisting is that there is no quote-unquote beyond marriage. We have to dismantle a structure which builds marriage into essential benefits. This is very, very specific, I want to be clear, to the US context. Secondly, and allow me to take this as bluntly as possible, I have no patience with the anti-assimilationist argument. That's not because I think assimilation is necessarily a good thing, but because assimilation is hardly the problem here. Following this vein, according to many queers, many of my fellow radicals, the problem with marriage is that it stunts, suppose this is how the argument goes. Yeah, the problem with marriage is that it stunts the flowering of sexual liberation and freedom and ends the supposedly joyous practices of polyamory and orgies. We know, of course, from even a cursory examination of the lives of Vertage conservative, that this is nonsense. You could then follow this argument, as many of my leftist colleagues sadly do, and state that what matters is that individuals engaging in particular kinds of marriage somehow transform marriage, that they have, for instance, open marriage as practice. But all of this misses the point entirely. You could technically be making 5 different people in your marital bed every night, but you would still never lose the benefits the state gives you because of your married status. So, all of this is to say that so far, critiques of being married have largely failed to tackle it head-on as an economic problem. And the point of the US is if we understand the deeply insidious nature of neoliberalism is that it's now necessary to not just think beyond, but against marriage. Current state of affairs in the US reveals unresolved contradictions of what passes for the left in this country. Liberals, progressives, praise gay marriage, or what they call marriage equality, as a mark of civilized progress, while they simultaneously scratch their heads trying to understand how and why this country is moving so fast and so brutally towards an intensely privatized state, where the most basic needs of people, housing, food, healthcare, and education, are simply not being met. In the US, again, this marriage often guarantees you much of that, whether explicitly or implicitly. It's marriage and the benefits we get, including the benefits of reduced taxation, which can have a great effect on your economic life. Taxation, of course, then brings me to Windsor and the question, how did liberals and leftists alike, who are otherwise constantly calling for a change in the economic structure of the US, fail to see that gay marriage is part of neoliberalism? So to answer that, I turn now to Edith Windsor, and I'm sure most of you are familiar with both her face and her story by now. She's at the heart of the dominant case, the Defense of Marriage Act. Windsor, who was not legally married to her longtime partner on the latter's death, was left with a large estate tax amounting to more than $363,000, which to most of us is a large amount of money. It's important to remember, and this is to vision, if you will, of a memento, a moment from Chicago's Pride celebration this summer. I want to talk a little bit about this T-shirt. I'll explain why in a minute. This came over. I doubt there's a rule celebrating Pride in Chicago because our Chicago summers are as intense as our winters are brutally cold, and the idea of 20,000 people sweltering all together on a mud street has never really appealed to me. But a friend of mine did go, and he sent me a photograph of this T-shirt, which was a T-shirt of Edith Windsor's face on it, and the words, "I am Edith Windsor." This was just after the Dover victory had been declared. So there were these people walking around in Chicago, with and celebrating Pride, celebrating the end of Dover, comfortable in the idea that they were all Edith Windsor now. This particular phrase, of course, is not to be taken literally, but it does speak to the general and more pervasive idea in the gay community that Windsor represents a grassroots impulse towards marriage, and that she is, in fact, every woman. It's important, in the context of understanding gay marriage as a manifestation of neoliberalism, to trace Windsor's acting history. The story of how she came to be at the center of what will undoubtedly be one of the most famous legal cases in LGBT history has a lot to do with how the gay movement strategically chose Windsor, having carefully picked her out of a bevy of cases. And we now know that various reports that Windsor was in fact carefully chosen as a perfect candidate, a grieving and very presenting widow, nothing explosive in her past life, exemplary social networks and connections. We have mounting pile of evidence of all of this in recent profiles in the Guardian.
Try calling it back.
Hello. Hi.
Hello.
Hi. Did that disappear for a bit? Shall I just continue?
We missed you for a minute, but
Okay.
you were talking about Edie Windsor on the T-shirt.
Okay.
We have mounting evidence of this from a recent Guardian profile.
Okay, is that all right? So I'll just start with that paragraph again. How's that? If that's all right. So it's important to consider, as I said, that in the context of understanding gay marriage as a manifestation of neoliberalism, the role that Edith Windsor has played in all of this, and she was chosen as the perfect candidate, a really very presentable widow with profiles in the new, and all of this, of course, we now know because of profiles in the Guardian and the New Yorker. But it's important to note that until the actual decision came down, Windsor was always portrayed as a somewhat stereotypical little old lady, almost, somewhere perhaps living in a dark New York City apartment, barely able to keep her lights on, and so on and so forth, in the face of what is, for many of us, a massive amount of taxes to pay. Over the course of the publicity leading to the case, lawyers for Windsor, the gay media, much of the liberal progressive straight media, and gay marriage activists assiduously worked at keeping Windsor's actual life out of view. Even the New York Times, which, as we all know, often takes pride in providing detailed and comprehensive reports, never once really discussed the actual value of Windsor's estate. The only publication to actually declare Windsor uncomfortable. We're doing this because as queer radical grassroots activists, many of us are involved in queer projects that have to do, for instance, with working with queers in the prison industrial complex, harm reduction programs around drug use, working with LGBTQ youth in street trade, sex work, as well as, of course, the more slightly well-known issues of LGBTQ housing and healthcare. We know for a fact that agencies and organizations working on these particular matters are often, as many of you might know, desperately underfunded and often scrambling for funds, while marriage fundraisers easily raise hundreds of thousands of dollars in single nights or a few weeks. To put it bluntly, no one has ever seen a Kickstarter campaign for marriage. Every marriage campaign has been ever launched in big and small cities has been well funded by organizations like the Human Rights Campaign and the National Gay and Lesbian Task Force and many others. As we did our investigation, what we found not only was the amount of money poured into the marriage campaign, but in particular, the actual value of Edith Windsor's fortune, which is by an extremely conservative estimate in the region of $7 million. Which is to say, I actually think it's more around $10 million, but a conservative estimate is $7. Which is to say, very few people, and probably not the people wearing those t-shirts, can actually be Edith Windsor. A worth of 7 to 10 million may not ensure your place to the right of the billionaire ex-mayor of New York, Michael Bloomberg, but I think we can all agree that it takes you quite far in most parts of the world. I emphasize this particular issue of Windsor's personal financial worth because she and her case represent the ways in which the gay marriage fight has been understood and regurgitated as a grassroots struggle engaged upon by millions of non-known gays and lesbians, when in fact, as our research shows, it is actually a massively well-coordinated campaign which has, again, by a conservative estimate, cost the community, by and large, over and approximately around $200 million. And again, just over the last 5-7 years. machinery of the state. In that sense, even critiques like that of Michael Warner have, to me now, a certain mustiness to them. It's not irrelevant to point out, as he has done and others have done, that marriage leads to heteronormativity. And Lisa Duggan's coining of the term homonormativity, of course, aptly describes the sameness of gay and lesbian social and political lives and dreams. But if we only focus on this particular set of critiques, and if we also ignore, as many people do, actual critique of marriage's role in neoliberalism, we leave invisible the much stronger economic critiques of marriage and gay marriage that have emerged since the 1990s with, if I may say so, with groups like Against Equality and several other people like Kenyon Farrow and Dean Spade, Eric Stanley, so many other people. In the end, to position the key problem with gay marriage as, in essence, being one about people fucking differently, or horrors not at all, is to ignore the much more insidious and pervasive role that marriage plays in the neoliberal state. And I'll just end with that and just open to questions. Thank you so much again.
Thank you, Yasmin. We do have about 10 minutes for some questions or discussion from the audience that can be directed to any of the panelists or all of them. And I think we've got a microphone, two microphones that are circulating around. So who would like to begin by asking anything of any of our panelists, including Yasmin?
Hi, I was just wondering maybe if I could hear a response from kind of the pro-marriage people up there to kind of the points of Yasmin's argument, that really shouldn't be our focus for, the future of maybe gay movements or the like.
Daniel, would you maybe like to handle that?
Well, I would agree 100% that it shouldn't be the only focus. Frankly, it's probably something that I personally spend less than 10% of my time on. There are a lot of very pressing legal issues in the state of Texas around inequitable age of consent, around the rights of parents to their children, around the curricula that's taught in our public schools that are far higher priority for me personally. However, I am a servant of and a tool of my community, and the overwhelming pressure that we hear from LGBT people in the state of Texas is you need to do more about marriage, to which my response is usually, great, here are some volunteer opportunities for you. I question the idea that it is easier to get money for marriage than for other issues. I can tell you, as someone who struggles to fund work in the state of Texas, that there is very little funding from national organizations on the issue of marriage for work in the state of Texas. In 2005, when we had our ballot challenge, there were significant out-of-state contributions from the Human Rights Campaign and from the National Gay and Lesbian Task Force, as well as from some private donors, including. But that was in response to a challenge that we had not placed on the ballot, that other people had placed on the ballot, and I can assure you that trying to get funding to put something on the ballot, there is none. From those large funders in the state of Texas.
I mean, Daniel, if I can intervene there, is that not in fact partly because many of the major organizations like the Human Rights Campaign think Texas is hopeless?
Oh, it is completely, or that we're not there yet, which I think is the more accurate assessment.
Whereas there are other states.
We are not there yet, where there are other
prospects.
states that are higher priority. But the way you get there is by working on it. Advancement doesn't happen if you're just sitting there twiddling your thumbs. There is work to be done in the state of Texas on marriage. But again, I would say it is not my personal top priority. Equality Texas's top priority for this most recent legislative session and the next legislative session is an inclusive employment non-discrimination law that applies to sexual orientation, gender identity, and gender expression for all public and private employers in the state of Texas.
Helmut, do you have some thoughts on this from a European perspective about whether marriage equality, to the same degree that it is a focal point of emphasis within the American gay community, should be or is the top priority within European campaigns for human rights for sexual minorities?
I don't know if I can give you a European perspective, but I can give you my personal opinion.
That sounds good.
Which is definitely European because I'm European. I would like to add two things. At first, I would like to emphasize in connection with my presentation what I did not make enough clear. Marriage, we talk about civil marriage, is nothing else than a registered partnership. We have to make that very much clear. We don't talk about a sacrament or a religious institution. We are talking about a state institution. So in countries where we have a registered partnership or a civil union, we have two kinds of registered partnerships. One is called marriage, and the other one is called registered partnership. So what sense to have there two kinds and two sets of law for two kinds of people? And even if, like in the UK and in many other countries, they have the same rights and obligations. But it's still important for some segments of society, we may call them our opponents, to keep it different, even if only the name and nothing else is kept different. And why is that so? Because it's highly symbolic. And with all respect, but I think Yasmin Nair's presentation underestimates this symbolic force of having one institution for all, and the symbolic force of having separated institutions for all. Why is it so important for the other side to keep it separate? I always hear the argument, well, it doesn't matter if it's separate, it doesn't matter if it has two names, as long as you have the same rights and obligations. Yes, it matters, because it makes you a separated group of people which is not worth to share the same institution and the same sets of laws. And we should not mix up two areas and two discussions which should be treated separately and which should not be mixed. One is about equality, and the other one is about what kind of laws and what kind of regulations are the best ones and which are worse or which are good and which one are bad. If you talk about Saudi Arabia, where women are not allowed to drive cars and cannot get driving licenses, would you say that it's we should not care and campaign for women also being allowed to drive and acquiring the freedom to drive cars, because from one point of view and maybe right point of view, driving cars is bad for the surrounding and for pollution of air and whatever, and for causing accidents, etc. And you can die when you drive cars. So would it be sound and or would it be compatible with human rights to say let's campaign for other things than for driving rights of women in Saudi Arabia, because driving cars is bad? That's not the issue. The issue is that, and I very much share that, I'm very critical of the institution of marriage, and I don't want to marry. But I want to be unmarried because it's my decision and not the decision of the Prime Minister or the President or any lawmaker or the state. I want to be unmarried because it's my decision, my free decision. And that's the very point. of course, the intensity is different, but it's the same problematic underlying, like women in Saudi Arabia driving cars, or employment. British employment cases, serving in the military. Would you have said, oh, don't bring this case, don't invest money in this case because military is bad? Which crazy person wants to serve in the military? We are against military. We should abolish the military. So gay people, lesbian people should not go to the military. So that's not an important issue. The important issue is equality. And the other thing is, should there be marriage? Should there not be marriage? Should there be one institution, 2, 20 institutions where you can choose from? That's another line of argument. The basic thing is all of these institutions, whether it be 1 or 20 or 15, they should be open for everyone, regardless of sexual orientation, sex, class, religion, etc. And it has, once again, a very high symbolic force for recognition and equality for same-sex people, not just couples, but for every same-sex loving person, as I may say that. Also in other areas. When you have one death battle, that will have a lot of effects and follow-up solutions in many other areas. But I also warn that should not be the only issue, and we should not end up in fighting only for conservative values, of course. But this is a very important issue, and we should not drop it.
Thank you, Helmut.
I'm really happy to some of that.
Yes, Yasmin.
Yes, can you hear me all right, Tom?
Yeah.
Yes.
Okay. So, well, I really need to respond to some of that. First of all, the analogy of Saudi Arabian women not being able to drive is rather similar, I think, to the arguments of monarchians in the United States, which is that, well, this is so very much like African Americans not being allowed to marry white people, or being allowed to vote, and so on and so forth. Let us first of all dispense with the idea that these are anyway analogies that are worth making. Those are completely different issues. Those have to do with, first of all, gendered and racialized histories, which are rather different from how marriage is functioning in today's contemporary society. So let's just put that aside for a minute there. But also, I just want to get back, I want us to get away from this constant emphasis on how, in essence, this is about the symbolic value of marriage, which is also, again, to me, a lot like the argument made in the US, which is that this is all about the religious right denying us our freedoms. The emphasis should not be on defining marriage or defining the state of things as they should be, according to how a lot of rabid right-wingers would define it. The emphasis should be on how do we create a system and a state and a society that guarantees everyone, whether or not they are married, access to education, healthcare, immigration status, and so on and so forth. So in that sense, what makes perfect sense would be a society that actually in many parts of the US we're moving towards, but all of that move has now been cut off because of marriage. What would make sense would be a society where people were able to simply opt into whatever kinds of relationships they wanted without any detriment to their well-being. So let me give you an excellent example, which is that of what happened to civil unions and domestic partnerships in states like Connecticut and Massachusetts right after they passed gay marriage. What did those states decide to do? Now, this doesn't obviously apply to certain private companies, but across the board, by and large, the state decreed that if you were even a straight person or a gay person in a civil union or a domestic partnership, you had, and I'm very particular, I'm going to emphasize this a lot, you were compulsorily forced to marry if you wanted to have your partner maintain his or her health care. So this is also, by the way, as far as I can tell, this is about to happen in Illinois as well. Some discussion about exactly how the laws would play out. So the point is not, it cannot, this is a very, to be honest, this is a very
Okay, thank you, Yasmin. With that, we're going to have to terminate this panel, but we certainly have opportunity to discuss further in the reception and cash bar, and there should be plenty of dainty food waiting for us outside. So we'll adjourn until 8 o'clock. Yasmin, sorry you can't enjoy the food with us.
That's all right. Thank you very much. I'll see you on Sunday.
Bye.